Welcome to Glorious IAS Academy. Today we are going to discuss about the fundamental rights. Today this is the first class of the fundamental rights. So fundamental rights inserted part 3 of the Indian Constitution, and article 12 to 35. Article 12 to 35 will be dealing with the fundamental rights in the Indian Constitution, and part 3 of the Indian Constitution will be dealing with the fundamental rights. So what do you mean by the fundamental rights? Fundamental rights nothing but they are the fundamental to the human all around development. Without fundamental right, you cannot expect the equal society. You cannot expect the freedom in the society. A man can evolve himself with the fundamental rights. So in the modern India, in the modern society, the fundamental rights are the very important for the all around development of the human beings. So first, the concept of the fundamental rights originated in the England. If you see, the concept of the fundamental rights originated in the year of the 1215. A king called John, he issued a written document that is called Magna Carta. Magna Carta of England. Magna Carta nothing but it is a written document. It enlisted the all fundamental rights that are required for the all around development of human beings. So English people demanded the certain fundamental rights in the evolution process of the England. In the various political movements, they are demanded the certain inalienable, fundamental and important rights to be enjoyed by the citizens of the England. So subsequently, the King John issued this fundamental document that is called Magna Carta. In the same way, the chapter 3 means the part 3 of the Indian Constitution, which consisting of the article 12 to 35, which are dealing with the fundamental rights, they are called Magna Carta of India. They are called Magna Carta of India. The Constitution of India guarantees certain civil liberties, and all Indians can lead their lives in peace and harmony as a citizen of India. So without fundamental right, you cannot ensure the safety and security in India. You cannot ensure the welfare of the people like SCs, STs, women and EBCs. You cannot expect the welfare of these downtrodden sections of the people. You cannot expect the social and financial and economic development in India or any part of the world. So the fundamental rights are very essential part of the human beings. So our Constitution of India guarantees certain fundamental rights under the article 12 to 35. So it is also called as Magna Carta of India and article 12 to 35. And we have inspired, our Indian Constitution is inspired from the American Constitution. Our fundamental rights chapter is inspired from the American Constitution, that is Bill of Rights. It is called Bill of Rights in the USA. Next one, the evolution of the fundamental rights. How this concept came from, where this concept came from. First, in the year of 1915, the King John of England issued the Magna Carta. Magna Carta nothing but written document of the all fundamental rights, all important essential rights, inalienable rights of the human beings. So next, after that incident, in the 1689, in the year of 1689, the Bill of Rights were written in the form consolidating all important rights and liberties of English people. So after King John issued the Magna Carta, all very important civil liberties and rights, they codified and consolidated and formed into the one written document in the 1689. So another important event took place in the 18th century, that is French Revolution. All political organizations, all student organizations, they all demanded single most important thing, that is fundamental and civil liberties. So as part of the French Revolution, the fundamental rights concept have been emerged in the France especially. So the French Revolution also concentrated on the fundamental rights. So the French Revolution has played a prominent role in the evolution of the fundamental rights. Next one, in the India, if you particularly the concept of the fundamental rights first time came in the Congress Party. The Congress Party appointed in 1928. In 1928, the Congress Party appointed Motilal Nehru Committee. See, under the Motilal, in leadership of the Motilal, a committee was appointed by the Congress party. This committee outrightly demanded a list of fundamental rights for the all citizens of India. A list of the first concept of the fundamental rights demanded by the Congress party in 1928. So after that, in 1950, our Indian Constitution came into commencement. So in Indian Constitution, Part 3 and Article 12 to 35 were included in the Part 3 of the Indian Constitution. Those are very essential for the all around development of the human beings or every citizen of India. So now we are going to discuss very important futures of the fundamental rights and some futures of the fundamental rights. So these are the futures of the fundamental rights. First, all fundamental rights not implemented to the foreigners. So those who are come from the other nations to the India, they are called foreigners. So some particular fundamental rights applicable to the all citizens of the India, but some particular fundamental rights not applicable to the foreigners. They only applicable to the Indian citizens. So that is an important fundamental future of the fundamental rights. So next one, they are not enforceable, they are not absolute. There should be some fundamental rights enforceable by itself. For example, Article 19, right to freedom, it enforceable by itself. But some other fundamental rights not enforceable by itself, they should be enforceable by the implementation of some particular rules and regulations or passing of some enforcement of some particular laws. So the parliament as well as the state government, as state legislatures and parliament, they should legislate some particular important acts to implement certain fundamental rights. So for example, right to education under Article 21A, that was implemented by the various bench of laws. So some are enforceable by themselves, some are not enforceable by themselves. They are not absolute. So another thing, they are not absolute. Absolute means you should not, since they are listed in the constitution, you should not enjoy them automatically. Some can be suspended in some particular situations. For example, during the emergency, national emergency, external emergency, all fundamental rights will be curtailed, will be taken away. Some except some few fundamental rights. So like that, some are negative in nature and some are positive in nature. And these fundamental rights against the arbitrary actions of the state and some are against the actions of private individuals. Like that, if parliament or state government or central government will implement something, that some laws or rules and regulations, if they taken away, if they act against the fundamental rights, so they will be declared as null and void by the Supreme Court or High Courts. So judiciary will be looking to the all actions, all laws passed by the parliament and state legislation. If they act against the fundamental rights, they will be abolished by the judiciary. So fundamental rights are acting against the arbitrary actions of the government as well as the legislature. Next one, they can be guaranteed and protected by the constitution, and they can be suspended during the emergency. Except Article 20 and 21 as well as the 19, all fundamental rights are suspended during the external emergency, but not during the armed rebellion or internal emergency. Only during the external emergency, all fundamental rights will be cancelled, will be abolished, will be taken away, except 3 fundamental rights like Article 20, 21 and 19. Next one, the scope of the fundamental rights will be limited under the Article 31A, 31B, 31C. These are the 3 important articles and which are limited. They will put some restrictions on the implementation of the fundamental rights. What do you mean by Article 31A? See, after the independence, there were some jamindars, some kingdoms are there. Some particular people, they are holding some estates, thousands of lakhs of acres they are holding. And after the independence and to central government taken those lands, those estates by amending some important acts. So the Article 31A, saving the laws, those will be taken away the estates from the particular prominent persons. So that in order to implement the equality, economic equality, and those lands, those estates distributed to the among other sections of the people. So in order to establish some economic equality, some social justice, some of the important laws that are passed by the parliament and state legislature time to time, and they will impose certain limitations on the fundamental rights of certain persons. So article 31A, that is one important article, and article 31B is a violation of acts and regulations included in the 9th schedule. It created some schedule that is called 9th schedule. Article 31B created 9th schedule, and various 13 important laws were included in 9th schedule. They cannot be, these 13 important laws, those are inserted in the 9th schedule, they cannot call null and void by the judiciary if they violate the fundamental rights. So whatever the laws included in the 9th schedule, even though they violate the fundamental rights, they will not be abolished. So in that way, it imposes some restrictions on the fundamental rights. So article 31C is a saving of laws giving effect to the certain DPSP. So these are the 31A, 31B, 31C. These are some of the important articles. Those will impose the restrictions on the fundamental rights. So next one, what are the fundamental rights? Article 12 to 35. Article 12 to 35 will be dealing with the fundamental rights and part 3 of the constitution. And part 3 of the constitution and article 31 to 12 to 35 will be dealing the fundamental rights. So what do you mean by article 12? Article 12 is dealing with the definition of state. What do you mean by state? What do you mean by state? That will be dealing with the article 12 give the definition to the state, and article 13 is the definition of law. Definition of law. So article 13 will be dealing with the definition of the law. So what do you mean by law? That will be deal with the article 13. What do you mean by state? That will be deal with the 12. In the subsequent slides we are going to explain what about the article 12 and 13. Here a right to equality, sum up as right to equality, article 12 to 18. Article 12 to 18, first fundamental right, article 12, article 13. So article 14 to 18 deal with the right to equality, 14 and 15, 16, 17, 18. These 5 important rights will be part of the right to equality. And next one, 19, 20, 21, 22. These 4 important fundamental rights comes under the right to freedom. And 6th and 3rd one, this is the first fundamental right, second fundamental right, and 3rd fundamental right is right against exploitation. Right against exploitation, article 23, 24. These 2 articles will be dealing with the right against exploitation. And 4th important fundamental right is right to freedom of religion. Right to freedom of religion, article 25, 26, 27, 28. 4 important articles will be dealing with the right to freedom of religion. And 5th important fundamental right is cultural and educational freedom. Cultural and educational freedom means 29 and 30. Article 29 and 30, 2 important articles as part of the cultural and educational freedom. And 6th fundamental right is right to constitutional remedies. So these 5 fundamental rights protected by the article 32. Article 32, right to constitutional remedies. Right to constitution. If any fundamental law violated by any action taken by the parliament, it may be state legislature, it may be central government, it may be state government. Any action done by these authorities, if they violate the fundamental rights, you can challenge those laws and actions under the article 12. So it will provide the remedies against the actions of the fundamental rights. So rest of the 5 fundamental rights are protected by the article 12, that is right to constitutional remedies. So these are the 6 fundamental rights that are given by that is inserted in the Indian Constitution of part 3. So remember, part 3 of the Indian Constitution dealing with the fundamental rights, and Article 12 to 13 are the fundamental rights. So next one, 6 important rights are there. 6 important, all articles codified into 6 very important rights are there. So as we discussed, some of the important rights are not applicable to the foreigners, those are living in India. So what are those? Article 15, 16, 19, 29, 30. These articles only applicable to the citizens of India, not to the foreigners. So rest of the articles, Article 14, 21, 21A, 22, 23 to 28, it is for the both, implement to both citizens as well as the foreigners. So Article 15, Article 16, these only articles you need to remember. You need to remember these 5 articles, only 5 articles only applicable to the citizens of India, not to the, and rest of all articles, all fundamentals applicable to both citizens as well as the foreigners. So what is the significance of these fundamental rights? What is the need of the fundamental rights in India or any part of the world? First, the welfare of the human society, promoting the welfare and removing the discrimination, removing the untouchability, providing all around development, whether it may be financial development, economical development, social development, so for and equality, establishing the equality and providing the fraternity and brotherhood among the all sections of the people, and especially upliftment of the downtrodden sections, means backward classes of the Indian society, means it may be OBCs, it may be SCs, scheduled castes, scheduled tribes, women's and handicapped persons, and there are certain special provisions created for this, the advancement of these special category classes, special backward classes. So for upliftment, for overall development of this human society, the fundamental rights are very important. Promoting the idea of the political democracy and right to vote, right to establish societies, right to association and right to freedom, these all promoting the political democracy. Political democracy will be dealing with will be part and parcel of the fundamental rights. For example, right to make association and student association, political parties will be established under the fundamental rights concept. So the promoting the political democracy is one of the fundamental principles of the fundamental rights. Next one, prevent the establishment and authoritarian despotic rules. The fundamental rights are imposed the certain limitations on the government actions. If any government actions, it arbitrary, it is against the some sections of the people, it against the fundamental rights, then these fundamental rights protect the people from the arbitrary actions of the government as well as the private persons. If any action taken by any association in India which is go against the fundamental rights, and it will be declared and abolished null and void by the judiciary. So that is the main fundamental concept fundamental concept of the fundamental rights. Next one, they are the operates certain limitations on the tyranny of the executive and arbitrary laws of legislation. We have discussed most essential for the all-round development of the individuals, and most of the fundamental rights are directly enforceable and they are self-executory, and some of them enforced by laws, certain laws. So some fundamental rights directly enforceable, no need to enforcement of any laws, but some fundamental rights, for example, providing the reservation for the OBCs, SC, STs will be implemented by the legislatures. So government has to, the parliament has to enforce certain kind of laws to promote these fundamental rights. So some of the self-executory, some will be implemented by the certain section, certain bench of laws. So that is the broad significance of the fundamentals. So in this class, we are going to deal with the 2 important articles. So far we have discussed what is the concept of the fundamental rights and what are the 6 fundamental rights, what is the significance of the fundamental rights, and what are the futures of the fundamental rights. So in this class, we will be dealing with Article 12 and 13. In next further classes, we will be dealing all the rest of the fundamental rights. So what do you mean by Article 12? Article 12 will be dealing with the definition of the state. What do you mean by state? State, the government and parliament of India also part of the state concept, and the government and legislature of the central government and Parliament of India also part of state, and state government and all state legislatures also part of the state, and all local authorities, local panchayats, they are also comes under the definition of the state, and all statutory and non-statutory bodies also comes under the definition of the state, and non-judicial functions of the non-judicial, not judiciary functions, non-judicial, that means administrative functions of the judiciary also comes under definition of the state. So according to the Supreme Court, a private body or agency working as an instrument of state also fall within the meaning of state. So what do you mean by the state? Under the Article 12, state could be any one of these following. It may be central government, it may be state government, it may be parliament, it may be state legislature, it may be local Gram Sabha, it may be local panchayat, it may be any body acting on behalf of the government of India or government of any state, and also all other administrative functions of the judiciary. These are all comes under the definition of the state. So any actions done by all these people against the fundamental right, those actions will be declared as null and void by the judiciary. So that is the concept of state under Article 12. So move to the Article 13, and before going to Article 13, some of the important judgment related to the Article 12. So Article first case is Naresh Sridhar Mirajkar case 1966. It is headed by the Hidayatullah, and what he said, and Article 12 and Supreme Court also comes under the Article 12. So in this case, judiciary should be put under the admit of the Article 12. So otherwise, the courts would be allowed to make rules which violates the fundamental rights. So according to the Naresh Sridhar Mirajkar case 1966, the Supreme Court given a judgment that Supreme Court also part of the, earlier we were talking about the administrative functions of the judiciary only comes under the state. But in this case, judiciary put itself under the Article 12. So in this case, the Supreme Court told that the judiciary, all functions of the judiciary comes under the Article 12. But in the next case, Rupa Ashok Hurra or Ashok Hurra case in 2012, the apex court ruled that judicial proceedings could not be said to violate any fundamental rights. So all judicial functions, any judicial actions should not be violate the fundamental rights, and judiciary will not comes under the Article 12. It reversed the earlier decisions. All according to the Rupa Ashok Hurra and Ashok Hurra case 2002, two important things are there. One important thing is the Supreme Court, the judiciary functions of the Supreme Court will not comes under the Article 12. Second one, the judicial action should not violate the fundamental rights. Next one, Riju Prasad Sharma case. 2015, very recent case. What Supreme Court told? Court held that when a court is acting in its judicial capacity, it cannot regard as a state. Same judgment given by this is the same judgment given by the Rupa Ashok Hurra and Ashok Hurra case. And here also same thing, Supreme Court says same thing. When it is acting judicial capacity, it will not comes under the Article 12. But it is acting in administrative actions, all administrative actions will be come under the, what is definition of the 12? So definition of the Article 12. So if you conclude that, so far right now, according to this Riju Prasad Sharma case, all judicial actions will not comes under the Article 12, but all administrative actions of the judiciary only comes under the Article 12. Only comes under the definition of the state under the Article 12. Simply put, judiciary functions of the judiciary functions of the all Supreme Court or High Court, any court will not comes under the Article 12, and as well as any judicial action should not violate the fundamental rights. So when move to the Article 13, Article 13 will be deal with the definition of the law. It is a definition of the law. Deal with the definition of law. So all laws that are inconsistent or derogation with the fundamental rights are null and void. So any law that is passed by the state legislature or the parliament, those laws acting against the violate the concept of fundamental rights, those will be declared as abolished, null and void by the judiciary, and that is called doctrine of judicial review. The concept of the doctrine of judicial review is implemented by the article 12. Under the article 13 of the Indian Constitution provides for the doctrine of judicial review. What do you mean by doctrine of judicial review? Every action, every scheme, every program, every law that are made by the state authorities or the central authorities, they will be reviewed by the judiciary whether it violate fundamentals or rights or not. If it is violate the fundamental rights, they will be declared as null and void. If it is not violate the fundamental rights, they will be allowed to implement. So every action did by the central government and the state government will be reviewed by the judiciary. That is called judicial review. The concept of the doctrine of judicial review inherently implemented by the article 13 of the Indian Constitution. So what and all require, what and all comes under the law? So permanent laws enacted by the state government and central government, and temporary laws, that means ordinance issued by the president at the central level and the governor at the state level, also comes under the laws. And statutory instruments means delegated legislation, means executive legislation like orders, government GOs, government orders also comes under the article 13. And non-legislative source of law, customs or usages having force of law, a non-legislative source of laws also comes under the, means laws passed by the parliament, laws passed by the state legislature, and actions and also ordinances, delegated legislations, and all other non-legislative functions did by the central government as well as state government, they're all under comes under the definition of the law. So with this, we are ending this fundamental rights first class 1, and subsequent classes we will be elaborately discussing about the article right to freedom, right to religion, cultural and other 6 fundamental rights. Thank you very much.